Call this meeting to order. Tonight, we're going to be led in the pledge by Mr. Richard Zago. Thank you, Mr. Zago. I'd like to welcome everyone this evening. This being our third policy meeting for this committee this year. Appreciate everyone attending and everything. Tonight we've got several items here that Ms. McLeod everybody's got an agenda on. If it's okay with everyone, if you just want to make a note versus voting on each one of these individually. Ms. McLeod's made a suggestion to me. We'll do number 1 by itself, 2 through 9 as a group, unless somebody wants to pull one out. We'll do number 10 by itself, number 11 by itself, 12 through 16 will be as a group. 16 is just on the agenda from last meeting. 17 or 18 are two separate items that I believe she wanted us to just take a look at tonight. So this time I'll turn it over to Ms. McLeod.
Okay, the first policy that we have, first of all, let me apologize for the manner in which you have these documents tonight. We've been on kind of a tight time frame. We just received the updates from TSBA yesterday morning, had a webinar on those updates today, so we haven't had enough time to send to them, get them to retype them for us and get them back, so I apologize for the format, but we wanted to try to get these in as quickly as we can to get them on the agenda for next week and possibly waive the second reading requirement so that we can get what we need to in our student handbook and in our teacher handbook for next year. So the first one that you have is 6.303, interrogations and searches. And if you notice on the first page, I've underlined and highlighted a sentence there that says the principal shall make reasonable effort to notify the parents, guardians, or legal custodians of the interrogation unless circumstances require otherwise. And this is under the category of police-initiated interrogations. This is on your agenda tonight to propose that we remove that sentence based on a February the 24th, 2014 Attorney General's opinion that asks the two questions: if a principal agrees to allow a law enforcement officer to interrogate a student at school about an unrelated crime committed outside school hours, must the principal first notify the child's parent, guardian, or custodian, or may the principal defer to the officer's instruction not to make such notifications? The second question is, if a principal requests law enforcement officers to come to the school to investigate and interrogate a student suspected of a crime involving the school, must the principal first notify the child's parent, guardian, or custodian? And the Attorney General's answer to both of those questions is no. A school principal has no legal duty to notify a child's parent, guardian, or custodian before a child is interrogated by a law enforcement officer. So, and then there's a legal analysis of that opinion and why the answer is no. So based on that opinion, we are proposing that we remove that sentence from that policy.
What does the police, if they come to school, do they have the legal, do they have to notify the child parents?
Of the interrogation?
Yes.
No.
For appropriate explanation for the no recommendation, I'm having a problem with that.
Their legal explanation in the opinion is, although a school principal acts in local parentis for their students, no statute, rule, or court opinion imposes a duty on the principal to contact the parent, guardian, or custodian of a student who is interrogated by law enforcement officers on school property.
Is that not a violation of student rights?
Not according to the Attorney General.
Mr. Holliday.
Nonetheless, I feel like it is an appropriate measure inside our Rutherford County school system for us to have a standard that is beyond the law and make reasonable efforts in deference to the community's interest, that parents would like to be informed if their child is being questioned. And so we're not in conflict with any legal statute if we make that notification to the parents. And I think that if we were to put ourselves in the position of parents or go out and speak to the community, I think overwhelmingly the wish of the community would be to be notified before their child is interrogated.
I'm-
Mr. Nichols?
I mean, I can only see what would happen if a child gets interrogated and goes home. The parents are going to be at somebody's doorstep. They'll probably be at the news media's doorstep, which will be here at our doorstep the next morning. And it's just gonna break out from there. Why are we doing that? Because they're already saying that SROs are in the schools to interrogate children. So, I mean, I think it'd be a bad precedent if we don't try at least to get to the parents, tell them.
Did TSBA recommend this change?
No. Oh, well, TSBA sent out the information in the Attorney General's opinion, but they have not recommended that change.
So if I, just speaking on myself, what I'm hearing is everyone, the ones that have spoken pretty well rather leave it the way it is.
That's certainly my feeling.
It's my feeling too.
Mine too.
With understanding that legally, the law enforcement community does have the right to isolate that child, take that child from the school campus, interrogate that child. They do have that right to do so, and we acknowledge that. And yet, we also have a responsibility, in local parentis to be the best substitutes for parental supervision that we can be. So, yeah, I would make the motion that we not accept this recommendation.
Well, we
Is
don't
it a
have,
recommendation, or is it just
she,
information?
Can we just go with no action?
with no action
Yeah,
is,
do you
Okay.
agree, Jeff? I don't think we have to necessarily, we're not making any changes, so.
No.
Do you think we need a motion?
I don't think we need a motion, there's no changes approved, and, it stays as is.
Okay, then we're gonna go through 2 through 9, and then have you vote at the end of those. All of these are based on legislative changes, so not things we have much of a choice about, but we'll go through those. First is 5.115, assignment or transfer, and I've highlighted that first sentence there for you. The date, May 15th, for notifying personnel of assignment should be changed to June 15th. And that's the only change in that one. Any questions on that? The next one is 4.400, instructional resources and materials. And if you'll notice then, the red section that I have marked through, and these are all based on TSBA recommendations and new legislative changes, that section would be deleted, and what will be added is, upon request, parents, guardians shall have the ability to inspect the following items: instructional materials, teaching aids, handouts, and tests that are developed and graded by their child's teacher. The director of school shall develop procedures for the inspection of materials and distribute those procedures to each principal, and that is required by statute.
My
And then the
guess,
second page is TSBA policy. I'll text you a copy for you.
my guess we'll get more instruction about how, maybe at the legal conference this summer, about how to do that. I mean, is it multiple times a year? Is it all time? How do you administer this? What type of notices and that sort of thing? We'll probably get more guidance, but this is statutory language as it is. We'll put out probably an ADM about how to apply it when they tell us more about how it needs to be applied.
anybody else? Number 4, textbooks.
Textbooks is 4.401, and the first change is that second paragraph will be deleted. What will be added is, once the proposed textbooks have been approved by the board, the director of school shall post a list of approved textbooks and instructional materials on the school system's website and send a copy of to the Commissioner of Education. And then the second change, where I've starred, this would be added there. Complaints and reconsideration. The director of schools shall develop forms and procedures to enable citizens to file complaints regarding the selection or content of approved textbooks. Following the conclusion of this administrative process, a complainant may appeal an outcome to the board. On the second page, under number 2, and this is something that Mr. Odom and I discussed today, this is not a statutory change. That says withholding of all grade cards, diplomas, certificates of progress, or transcripts until restitution is made. We're talking about what you can do if a student has not returned a book or paid for a damaged or destroyed book. I generally advise principals not to hold diplomas. We do hold transcripts if necessary for high school, but have just found it not to be a good practice to hold diplomas. So if we're not doing that, we feel like it would be best to eliminate that. Now, the next changes that we've added there, we put these in just to reflect that TSBA has these in their policy. And number 3 allows the principal to not allow the pupil to take an interim or final exam or to earn course credit in the course for which the textbook is prescribed until restitution is made, or to reduce the pupil's grade in the course for which the textbook is prescribed by 1 letter grade or 10 percentage points until restitution is made.
I don't like to connect discipline and grades. I mean, even though TSBA is recommending that, I'm not real comfortable connecting the two. I think they're two different things, much less reducing the grade. Plus another thing, very difficult for schools, if you don't let them take the final exam, they do make restitution, then they have trouble getting closure. Then a week later or some other later, are they going to have to go back and give one test to one student and that sort of thing? You'd rather do something that you can kind of deal with it at the time, I think. I just don't like to connect discipline with grades.
So we're not necessarily
That's me.
proposing that we include those, we just
No,
wanted you to know that
TSBA
those are
had it.
TSBA's model policy. So if everybody's okay with not adding those, that was just for your information. Then the part that is required following that is the inspection section. A list of textbooks used by the school shall be revised annually by building administrators under the direction of the director of schools. Textbooks shall be available for inspection by parents, guardians upon request. The director of school shall develop procedures for the inspection of materials and distribute these procedures to each principal. And again, that will be something that we will be looking at developing an administrative procedure for once we have some additional information.
Is everybody okay with not including 3 and 4? Or how do you feel about it? That's my,
I agree with you, Mr. Odom.
We haven't been doing that up to this point.
no.
We'll just scratch 3 and 4 off here when we get ready.
We just included that for your information.
All right.
Yeah, go back, what you were saying about the appeal to the board, tell me what you have on there for that. Objection to textbooks. What was the specific language you had as far as the right for people to appeal to the board regarding textbooks?
The director of schools shall develop forms and procedures to enable citizens to file complaints regarding the selection or content of approved textbooks. Following the conclusion of this administrative process, and the complainant may appeal an outcome to the board.
There's some statutory changes that deal with textbooks, and I assume this must be part of
It
it.
is.
Does the board have to hear that appeal?
I only see direction that we post the approved textbooks. I don't see statutory direction for the complaint and reconsideration process.
I think it's kind of cut off down at the bottom a little bit, mine is.
Well, the part that I have written, cut off there, but you see in TSBA's policy that line 11 through 13,
Right.
are what is complaints and reconsideration.
And that certainly is something that is not in our policy currently, but I don't know if it is new in this 2014 version, or if it is another thing like 3 and 4 that we had previously chosen not to include.
Now, this is one of the topics that we covered in the webinar today, that was required,
Really?
that they said was required. I can go back and look at the statute, and I didn't bring a copy, but I have it in my office to look at, see, make sure that that's included, but they did cover that in the webinar today.
The summary that Lonell Green put out. It just says that the policy was updated to reflect a revision to TCA 49-6-2207, which requires that once the proposed textbooks have been approved by the board, the director of schools shall post the approved textbooks on the school system website and send notice to Commissioner of Education. And it ends there. A complaint and reconsideration process may be appropriate, but I wonder if
Well, I
we
think
want to give it more
we may want to
consideration.
look at the statute a bit more on that before we decide. to
I
do that.
have it, we get to the end of this, while you're discussing that administrative procedures, I can run and get that, see if it's in that, I have the statute.
And it could be edited when we get to the board meeting for the actual policy, if we have to. Whatever you want to do.
Well, let's,
I was also a little concerned about the inspection. A list of textbooks used by the schools shall be revised annually by the building administrators. So it seems like that could be interpreted as the board may approve these textbooks, but then in that 6-year cycle, if the principal wants to change it, then on an annual basis, he has the opportunity, he or she has the opportunity to make a revision. Surely that's not what that
I don't
says.
think that's the intent of it.
I
Okay,
don't
then
know
I-
how they could with the expense.
The way I read that is he will keep an up-to-date
List.
list, and if it changes through whatever power exists, not his, through the school board or through the state, then he will add that revision to his list.
Yeah, I kind of saw that as a, you know, if there happens to be one that they use one year and they don't use it next year, it could be off the list. But, I mean, nothing would ever come that wasn't on the approved list by the board.
All the inspection and the challenge needs to come before the board has to vote on it. Because once you adopt it, we have to send the form in to the state. So, I mean, all of those things need to come ahead of time. It's kind of like horses out of the barn, now let's talk about it. I mean, that doesn't, I don't understand the sequencing.
What would be the scenario that they would make a change?
And the state all along with textbooks have placed them for public to review. MTSU is typically the place here. As I read the statute, as it was being discussed, I was kind of following the legislature. One of the things that they were going to say to textbook publishers, if you're going to bid it in Tennessee, that you'd have to post it online for people to view and look at also. Now, whether that's stuck through all of the details of the legislature, I do not know. But I think the state is building in their selection process something for statutory about people being able to review it. But I guess I don't understand reviewing it after you've approved it.
Well, the way I see it, there'll be changes this year. Some new textbooks have been approved, so the administrator is responsible for having that list present when school opens. That's the list we're talking about, not his discretion to change anything, and he doesn't want that discretion, believe me.
But our textbook department maintains it anyway.
Yes.
Because we do that, and then with inventory, textbook inventories, which we do annually, all the books are listed on that. So we have it, and they've had it
So
for
he will
years.
have a list of those at the
So
school.
it would be like if you offer
Or she.
Latin this year, but you didn't offer Latin next year, and that list of books for that school, that Latin book would be taken off, because that school wasn't offering that course.
You could, if that's what it means.
That's kind of how I.
That's the only way, yeah.
That's how I read it, was that if
Okay.
if you offered a course and the next year you weren't offering it.
Just
you
take it
would
off the
take that
list.
off the
Okay.
list. Similar to, they've required us to list lots of things per school now, so that,
Mm-hmm.
it's not just the general, so that parents can go to a school's website and see their list of books, not the list for the entire county, but what they're using at that school. And I read that just to be that's a further, so
Okay.
that they can only look at that school's.
If keeping a current tally of what books are actually being used and in the classes that are being offered is the intent, then I would suggest that it read, a list of textbooks used by the schools shall be kept current by building administrators, and that takes away the revised word, which I find problematic, which suggests that there's some editorial opportunity there.
I'd still
So-
put it annually.
Ms. Wise has mentioned put kept current annually.
Okay, kept current annually.
list change though, periodically, I mean, by semester? Could we like take away a class?
Well, there's some half-credit courses that might be first semester and second semester, but, I don't think that'd be an issue if you offered it in that academic year, would be my thought.
I was just wondering about annually, if, how current would we keep it?
Annually, it cover you for the year anyhow.
I mean, once a year.
Once a
Once a
year,
year.
at this point.
At the end of the year, if
Okay.
you wanna rework it, you rework it, or update it.
I'm getting confused here. Textbooks, we're talking about changing textbooks after they've been adopted for the system, or,
Apparently, I mean, that's not the way they're reading it. I don't see how you could.
well, I don't either. How much leeway are you asking for, decisions to be made on the school level on what textbook to use, or how does
They all-
it?
They all come to you, and we have to send it to the state.
Yeah.
You know, which textbooks used with which course. So we have to report that. And
Well, that's what I'm saying. If you got a list of textbooks, we can get so many wordy things in our policy. If we have a list of textbooks and we have a list of courses and a selection is made for that course, then as long as that textbook is adopted, why do we have to revise it or anything else? Looks like it pretty well should take care of itself.
I think, if I understand it right, I think what you're doing when you have adoption go, you know, if you go six years or whatever you're doing this year, and then next year, you have something else come along, and you have something new to the list, you're basically just updating the list, or approving the list, updating the list.
I think this was some of the reaction to the
I think all.
textbook thing that went on in the legislature this year, and some of the language just kind of got added, is my opinion.
All right, if you update the list, it's not updated for school X, school Y.
Yeah.
It's updated for the system. And
Except for special courses, and you could we still have to list that, you still approve special course textbooks. So it could still be on the system list if the course isn't offered.
But once that special course is approved, a textbook is approved for it, why do we go any further?
I agree.
It's, you know, we just, I'm having trouble seeing the complexity of this thing. I have a tendency to oversimplify a lot of things, but it looks like that once you settle on the course, you settle on that textbook, we know that in this day and time that things are constantly revised. And we know that we can obtain those revisions as needed at a cost. So it would be for that individual, but it would be done on a system basis and not individual school basis, as I see it.
I see this as an effort to inform the parents or the public, if you would, of what textbooks are available, are being used at that particular school where their child is in attendance.
Right.
That's how I see
And
it.
that
Now, if it means
textbook is-
something else, I'm lost.
Right,
And we
and
might
that
wanna put this-
textbook that you're showing parents at school X is gonna be the same textbook at school Y that you're gonna show these parents.
Perhaps. There may be slight deviations if you're not using certain books, if you're not teaching certain subjects.
See,
Or
that's
courses.
where I think we're making this thing too.
You got to
And
change your
when you
list.
use the word
That's
But
perhaps,
typically, on a 6-year cycle,
I
it's a
don't
different
think this should
curriculum
be a
every
perhaps.
year.
Yeah,
I
Well, I think we probably need to put this one with the other one, let me pull the statute, because there's a statutory reference, and I'm not sure we have a choice about it.
See, I don't understand the complaints and reconsideration, that's the piece that I do not understand after the fact. Now, we've had a complaint process for somebody that doesn't like a library book, I mean, that's been in your policy manual for a long time. People could file a complaint on another book, but I don't understand necessarily some of the statutory language that might be in this.
I think both sides are right. I mean, Mr. Jernigan here is talking at textbooks at a system level and maintaining the list there, where we only have to do it one time over that 6-year or whatever adoption period. Mr. Eakes is right when he's talking about the schools and the individual textbooks for that school. But we shouldn't equate textbooks to a school like they do like if a parent wants to go see what is at Laverne, what's being taught at Laverne, they go look at the course at Laverne High, and then they can come to the system and look at what textbook goes with it. That way it can be kept at the system, at the district office here, and maintained but one time. I believe that's what you're thinking.
I just want, we're talking about equity in the system and everyone, we're doing so many things now that are made system-wide decisions. And my thinking is something as important as curriculum, and I know that people say curriculum and textbooks don't necessarily have to be the same, but in reality, they are looked at that way. And, you can't be changing, in my opinion, textbooks based upon someone doing a complaint form. If they fill a complaint form and that complaint's upheld, in my opinion, that would not be something that was a complaint against that school. That would be a complaint that was upheld that affected the entire system where that textbook is used. Am I looking at this thing wrong, or?
That's why I said it needs to be done before the selection is made.
Right.
You just can't make, at the cost, the textbooks, you can't start changing after the fact.
To help me understand the debate, are we saying that, say if Algebra 1 is taught in the system, that each school gonna have a different book, or have a choice?
We do not buy different books, see,
Okay.
because it's a bid process.
And that's, excuse me for speaking out like this, and that's what I was talking about, keeping the list of textbooks here at the central office. And each elementary that has a website, all they have to do is take that course and put a link over to the textbooks here. You only have to keep one textbook that has been approved, or one version or whatever here. And that way you don't have 10 different or 20 different textbooks on 20 websites.
There is a case where, for example, if you were doing a dual enrollment course, and somebody was doing it at Motlow and somebody was doing it with MTSU, it may be the process that we would have to post both in those cases, because I could see where that would happen. In other words, Motlow says before we're going to give dual credit, you have to use. In fact, we ran into some of that, I think, Mr. Ash, with a U.S. history book or something. Didn't you have to use Motlow's history book for them to give dual credit? So we can work through that, but there'll be minor cases like that where you might have that situation.
Mr. Chairman, could you let Ms. McLeod read this? My copy's cut off here at the bottom for the complaint for reconsideration. Could you read that again?
The director of schools shall develop forms and procedures to enable citizens to file complaints regarding the selection or content of approved textbooks. Following the conclusion of this administrative process, a complainant may appeal an outcome to the board.
So what is the actionability of the board with a complaint? I mean,
Well, I mean, first of all, we're gonna check the statute and make sure that we're required to include that.
okay.
But, I mean, depending on what the outcome was of the administrative process, you know, if they upheld the content of the particular book, then you would look at upholding that or overturning that, making changes.
So the board would either toss the book, keep the book, or make changes to the book?
Mr. Holliday?
Just to help us all wrap our heads around this, when I'm considering this, what I envision are English reading lists, history reading lists, and even though we may be on a 6-year textbook adoption cycle, the books for that course would be correct to include those books that an instructor would require be read during the course of the year. And so in that English class, To Kill a Mockingbird, A Separate Piece, and Red Badge of Courage may be in addition to the textbook approved by the Board of Education. And it would be appropriate to have those listed. And if we had a teacher change before a 6-year textbook adoption cycle rolled around, that teacher might change the novels or supplemental books that are part of that course, and thereby this policy would say, building administrator, it's your responsibility to update that list so that we have an accurate record of the books that are being used in that class. And that could potentially, in fact, almost likely, would be site-specific as well. Those books might be different at Central Magnet than they are at Oakland, than they are at Riverdale. And I see that as the intent of this.
I don't think it, I mean, in my opinion, this does not contemplate, these are approved textbooks.
Yeah.
Textbooks, not
We
something
actually do a
that we-
district list for reading too. Well, the teachers come in and meet and they do summer reading lists.
Right.
Now, students can sometimes select from 8 or 10 books, like you gotta read 2 of these or 3 of these,
I
but
think that would
we even do
certainly
that
be
in the
something that
district.
would be required for inspection under the instructional materials policy that we're gonna have to do our forms for. But this, in my opinion, contemplates textbooks,
Only textbooks.
not supplemental materials.
Okay.
And this is a close cousin to what we did about a month ago with the other textbooks. This is akin to that, and the fact that those books have been approved, they'll be in the schools next year. That list will be there for others who may not be aware of what books are being used to peruse and see what's being offered.
I just don't understand the reconsideration after the books are selected.
Yeah,
I think the complaint's gotta come before you do it.
That's
That's what I don't understand.
Because
Because once you've bought it, you've got another issue.
For this statute.
Let's, if it's okay with the committee, let's, Ms. McLeod wants to take a look at that at the end, so let's just, let's pull number 4 out of this whole scenario and just put it down at the bottom of the page, and, we get towards the end, we'll let her get that information, and, she can go over it and Mr. Reed take over, or vice versa, so, number 5, Ms. McLeod.
Okay, the next one is 4.700 testing programs, and you see at the bottom of the page, we have deleted, and the proposed revision deleted those last 2 paragraphs. They reference gateway exams and percentages for TCAP and of course exams, and if you flip over, this is the second page of TSBA's model policy. The first paragraph would add in our percentages for Tennessee Comprehensive Assessment Programs that I've written above there. Grades 3 to 5 would be 20%, 6 to 8, 25%, and 9 to 12, 25%. And then the statutory changes then are lines 9 through 19 regarding requiring the board to publish on its website information related to state mandated tests, and any other tests that the district is administering during the year. We have to include the name of the test, the purpose and use of the test, the grade or class in which the test will be administered, tentative date or dates of the test, the time and manner in which parents and students will be notified of the results of the test, and the beginning of the 15-16 school year, and thereafter, we also have to include this information in the student handbook.
Do we have any questions?
And we've basically done that for a long time on state mandated tests. I mean, the TCAP dates and the course dates, especially the tests are on our website, have been there. It could be that if you do any district benchmarks or something, that may have to be added. That may be the possible change.
Aldo?
Why are we moving the percentages?
What we had originally had in was that student scores on the Tennessee Comprehensive Assessment Program and of course exams will comprise a percentage of the students' grades. And that was at the time that it was fluctuating and we were deciding, you know, what percentages would be. We've decided on these percentages and intend to keep them that way. So,
Statutory, I can tell you the history on this. The statutory thing says that high schools is set at 25% by the statute. We have no choice.
Got it.
We could go between 15 and 25%, up to the local board. You just had to report to the state for 3 through 8. Basically, we selected, and middle school principals met, we selected 25% because we teach some high school courses, Algebra 1 and some others, in middle school. So at that time, the selection was, let's just keep it 25%, so it's consistent. Then this board chose 20% rather than 15% for the elementary, which would actually be 3 through 5. But they give you statutory right for a board to choose between 15 and 25 for 3 through 8.
And we chose 20%?
For 3 through 5 and 25% for 6 through 8. That's what this issue was on the news media this week, if you want to know. When the scores were coming in late, this is the application of that. That's exactly what this is.
Any comments? All right. Go to number 6.
number 6 is 4.802, student equal access, limited public forum. And again, these are recommended by TSBA due to statutory changes. We would eliminate lines 1 and 2, and the policy would begin with, schools may allow students to form clubs that meet before, during, and or after the school day. Requests to form such clubs or groups shall not be based upon a religious nature or beliefs of proposed clubs or groups. If permitted, school administrators shall ensure all clubs and groups have the same abilities to access facilities and advertise meetings. I eliminated that first sentence because we had in that policy, for some reason, before the beginning or after the end of the school day, students in grades 9 through 12 may initiate non-curriculum related meetings regardless of the religious or political nature of the meetings. And I'm fairly certain that we have those in other grades, in middle school grades as well, so just to make them consistent throughout the system. Also, the section added is school-sponsored events. If the board, and this is a new statutory change, if the board or a school principal authorizes an event at which a student is to speak, a limited public forum shall be established for such student speakers. The appropriate administrator shall ensure that the forum is provided in a manner that does not discriminate against a student's voluntary expression of a religious viewpoint, if any, on an otherwise permissible subject. Number 2, there is an appropriate method of selecting student speakers which is based on neutral criteria. And number 3, student speakers do not engage in speech that is obscene, vulgar, offensively lewd, indecent, or promote illegal drug use. On the second page, to the extent possible and practical prior to events in which students will speak, notice shall be provided orally and or in writing that the student's speech does not reflect the endorsement, sponsorship, position, or expression of the board and its employees. Beginning with the 2015-16 school year, notice of this policy shall be provided in student handbooks and staff handbooks.
So all this is statutory, right? Any questions, comments on this? All right, number 7.
Number 7 is recognition of religious beliefs, custom, and holidays, 4.803. On the first page, we added number 5, the school district's calendar shall be prepared so as to attempt to minimize conflicts with religious holidays of all faiths. All students and staff members shall be tolerant of the views of others. Students and staff members shall be excused from participating in practices which are contrary to their religious beliefs. On the second page, we added the section, student expression of religious viewpoints. A student's voluntary expression of a religious viewpoint on an otherwise permissible subject shall be treated in the same manner as a student's voluntary expression of a secular viewpoint. Students may express religious beliefs in homework, artwork, and other written and oral assignments free from discrimination based on the religious content of their submissions. These assignments shall be judged by ordinary academic standards of substance and relevance against other legitimate academic concerns. A student shall not be penalized or rewarded on account of the religious content of the student's work.
Ms. Mitchell had a question.
Ms. Mitchell, I'm sorry. I didn't-
I'm sorry, you probably got the same answer. On the student equal access, I had a question on the number 2 note that you put down there on that first page. It says there is an appropriate method of selecting student speakers.
Oh, on the previous policy?
Yes, ma'am.
Okay.
Is that appropriate method somewhere in administrative policy, or how do we know what the appropriate method is?
Well, I mean, this policy doesn't designate what the method shall be. It just says that it has to be based on neutral criteria.
And where do you get that criteria?
I mean, I guess each school has their own. It's not something that
So
we.
it's up to individual students then?
The statute didn't define that.
I mean, it just says it has to be neutral.
Well, just to continue on that thought, does that refer to the school or to the club or group of individuals? Would they decide who their speaker is going to be based on their criteria, which might be viewed by the administrative staff? Or would that criteria be established by the administrative staff? I think the second part goes to you. The first part says, are we referring back to the club, the group, the organization, to establish that criteria to determine who their speakers are?
And this section is referring to any school-sponsored event, and it specifically says the school principal, if the school principal authorizes an event, an appropriate administrator shall ensure.
Okay.
And it lists those 3 things. So it would be
Okay,
a-
so that would have to be passed
The
along
administrator.
once you establish that.
Mr. Hardow?
Sorry, but likewise on that same policy, but at the very beginning, it seems confusing to me. Requests to form such clubs or groups shall not be based upon the religious nature or beliefs of proposed clubs or groups. If we are requesting a Christian organization, isn't that a religious request? Or is it the approval of that shall not be based on the religious nature of the application?
I see what he's saying. It would happen, the request wouldn't be the question, the approval would be the question.
Yeah, because the request may be very much based
Could be
on
anybody.
a religious principle.
TSBA. It's
And
in
I
there.
apologize, what that should say is, request to form such clubs or groups shall not be denied based upon the religious nature or beliefs of the proposed club or group.
Thank you.
Sorry about that.
No problem. That just helped a
Thank
little
you
bit.
for pointing it out. Makes better sense.
Yep.
Denied.
But that's what you got on the back anyhow, right? TSBA?
Right.
Okay.
I just got that word out, sorry.
Uh,
All right, so are we ready for 5.200?
yeah, number 8,
Okay,
unless,
and we can still take 8 and 9 together because the changes are exactly the same.
Oh, wait, I'm sorry. 4.803, were we done with it?
I don't think anybody had any questions on that.
you
Okay,
have,
We
sorry.
went back to the previous one, I'm sorry.
I know we did, I'm sorry. The school district's calendar shall be prepared so as to attempt to minimize conflicts with religious holidays of all faiths, this is gonna be a statute thing.
Yes,
Don't have any choice.
right.
I asked her about the word calendar, and that's in the statute, apparently.
Do we have a list of holidays that religious holidays we will adhere to? I mean, you said there's a number of them here, I think.
I'm not sure, when you say adhere to, what?
Well, I mean, we allow religious holidays to take off, kids to take off for certain religious holidays.
As long as we can verify that it's an actual, religious holiday observed by that particular religion, we always grant an excuse
Just
absence
excuse that.
for students.
But an excused absence is one thing. Structuring our school calendar is a completely different circumstance.
But Mr. Oden and I discussed that just briefly today, and I think that, the only thing you could really contemplate looking at is if you were going to have, you're gonna build in 3 teacher workdays, if you could possibly make that coincide with a religious holiday, that would be an attempt to accommodate. I don't know, there's not much flexibility in the school calendar, so I'm not sure how you would ever do much in that way, but at least, I think what they're saying is, you should at least be mindful of that when you're looking at your student calendar.
Okay.
Anybody else? All right, number 8, 5.20.
Okay, so 8 and 9 are 5.200 and 5.201, and they are separation practices for tenured and non-tenured teachers. And what has changed in both of those policies is a new statute that requires, and I've listed it on the very back page of each of those. It requires a new section regarding suspension, pending investigation. And essentially what this says is that if the director of schools suspends either a tenured or non-tenured teacher, that they cannot continue that suspension for longer than 90 days without going forward with charges for dismissal before the Board of Education or independent hearing officer, or if there is a criminal investigation or a Department of Children's Services investigation pending, you can go beyond that 90 days. But essentially just to say, you can't just put somebody on unpaid suspension and just let it go on and on and on without taking some further action, and that's to be added to both of those policies. In the non-tenured teacher policy, 5.201, we also had, I'm sorry, it's 5.200. On the first page, our language indicated that the board would choose an independent hearing officer if there was an appeal. TSBA's policy suggests that we maintain a list of hearing officers, and then once we have a request for an appeal, we would just choose from that list. Mr. Oden and I talked, and that seems like a more efficient way to handle it, so we added that language in, so we would present a list of people to you in August to use for that school year, and then if we had those appeals come up, we would choose from that list.
I thought we did that last year.
I think you got 3 or 4
What
of
we
them.
did last year was a panel of 3, but in this circumstance, we'll just have a list of people that we can choose from for a school year, more than 3 probably.
Okay.
From there, TSBA maintains a list of people that they recommend, so we do that.
So you're saying when you say we choose, you're talking about the board choosing, or?
You would approve
No,
the
once you had
list.
approved the list,
Right.
then Mr. Odom would choose from that list if an appeal was asked for.
Okay.
And he'll bring that to the board.
And it works better that way as well, because it's on a pretty tight time frame. So if we don't have to bring that back to the board each time we get an appeal, we can move on with that process.
All right, anybody else, Ms. Holiday?
Before you go into voting, I need to go back to number 2. I did not see this in TSBA's recommendations. Is this a recommendation from Rutherford County Schools, or is this a recommendation from statute?
No, this is a statutory requirement. Actually, I think that when the notice of non-renewal date changed, we added that date, we changed that date, but we did not get the June 15th date in. So it's probably an oversight on our part, but it is statutory required.
Thank you, that's all I need.
Anybody else?
Do you want to wait to vote until I check on this one?
Let's pull number 4 off. Let's just go ahead and do the rest of them.
Pardon me, let me ask that same question one other way. Do you expect that the statute says on or before June 15th, and we could leave it at May 15th? Or do you think that it says June 15th and you shall use the date June
It
15th?
says by June 15th.
By,
By June
By June
15th.
15th.
be on or before June 15th, so it would be the same as.
We don't want to continue to use paper.
Okay.
Anybody else? If I get a motion, we'll vote on, number 2, 3, 5, 6, 7, 8, and 9.
Move to approve.
Second.
Got a motion by Mr. Blair and a second by Mr. Eads. Any further discussion on these items?
I've got a question mark by
Okay.
4.802. Give me just a second. Oh, you answered it. Sorry. I'm good now.
Anybody else? All in favor, say aye.
Aye.
Any opposed? Motion passes. Number 10.
Okay, number 10 is 6.200 attendance. We made a couple of changes on the first page. Strike through absences K through 8 and absences K-12. And if we just combine those together, there's absolutely no difference in the way you apply those. What you see underlined in that next to last paragraph, students who accumulate 6 or more unexcused absences in class during the semester, or a total of 10 excused or unexcused, will not receive credit for the class. In the case of emergency or significant extenuating circumstances, a request for an exception may be made in writing to the principal. And we put this in here for discussion because obviously this is something, you talk about absences and students not getting credit, and then principals having to deal with people appealing, based on extenuating circumstances, and it just being an ongoing issue. So we thought it may be something we wanted to revisit and consider making out.
I actually, unbeknownst that they were coming tonight, happened to call the two principals sitting out there and ask them, how do you apply this? And so they both gave me a pretty good answer, if the committee wants to hear any of that. Basically, how they felt about it.
Mr. Spurlock, Mr. Ash, either one of you like to speak?
Yeah, I'll go back and repeat what I spoke to Mr. Odom about, is there are extenuating circumstances. And I think Mr. Odom mentioned something earlier pertaining to punishment as opposed to behavior. We would like to think we teach responsibility in school. We support responsibility. Responsibility is taught at home. And by the time they get in high school, there's a possibility they may miss more days than that. When we do our best by allowing incentives for being in school, and when we do the exam exemption at the end of the school year, we do some things throughout the year that recognize those that have perfect attendance. But there are extenuating circumstances. I know in each school is different, so I would like to think that we could have a little leeway as principals, because this does create a huge burden on us. And at the same time, I'm all for attendance. Our attendance, when I first got to Oakland, it used to be daily attendance was 92%. We're progressively 95%. We've raised that through things that we've done internally. But there's always going to be that outlier where the grade, they pass the subject matter, and the attendance, if that is used as a barometer as whether or not they get credit, that would create a major issue.
If you have a kid that misses 6 days in January, and it says no credit, what kind of students you gonna have the rest of the year? Mr. Ash, I'm sorry.
And I kind of feel like it's double jeopardy, because in Rutherford County, we're fortunate that we have a pretty good juvenile system. And when we get to 10 unexcused, those students, and really the parent, are gonna go before the judge, and that issue's gonna be discussed. And there's gonna be a penalty for that, or encouragement by the judge to take care of that. But then we wanna penalize the child too, and say, you went before the judge and you can't get that credit. It's kind of like we're not trying to educate them as much as we're trying to make them follow the letter of the law and punish them 2 times. I don't know that I agree with it, but where I went to a private school, military academy, and our valedictorian was a day student, and he missed over half of the days. But he could still do the academic work. at the end of the day, if he's doing the academic work and can earn the grade, and he's not at my school, for whatever circumstance, I don't really feel good taking that credit away from that student if he has that knowledge. So I think we're doing two things there, and I don't know how much I can encourage a kid if he has it, because they have real circumstances sometimes, that they miss 6 days in January, and I've got to encourage that kid to keep trying the rest of the year, or you're almost condemning him. So I think we have something in place that takes care of the unexcused absences, and it's separate from academics. And I don't want to be a judge and jury and hear the stories that, can't you excuse this, this is what happened, because I want to be fair and consistent. Well, if I have to hear 50 cases of it, I'm not always going to be the same. If that's not in there, then I don't have to make that partial or impartial judgment. It's just taking away that the attendance is one issue over here, academics is standing by itself over here. And when we cross those two, I don't know that we're getting production that we want, and we're not. Some of the students I have in Oakland have, those kids need positive reinforcement through hard times. And we're kind of pushing them down and saying, you're right, you can't make it, you're not getting credit for it.
Questions?
I just agree totally with what they've said. You take away that incentive to do your work once you punish, especially as you mentioned. And when you look at the earlier grades, we know that the kids are in no way responsible for not being in school in the early grades. It's not, you don't have 3rd and 4th graders driving automobiles to school. So it's a parental thing, and you end up punishing the parents, and they do have a good system. Judge Scott does a tremendous job along with her staff at addressing that situation. So I agree totally. Thank you, gentlemen, for your input.
So we're okay with striking that? Okay, the next change is going to be on page 3. By TSBA's recommendation, we're eliminating lines 4 through 12, based on what you see there in asterisk that will be added in that section. We also added in line 18, this section covers excused absence for military service, a parent or guardian. Just to clarify, we had another section that says, that clarifies what's excused and not excused, but this is specific to military, so I thought it was more clear if we added for military service, a parent or guardian. And then if you flip over to the next page, these changes are based on a regulation by the State Board of Education. They require, part of the regulation requires an appeal procedure, which we already have in our policy. What we didn't have was adding some time frames in and then the notification back to the parent after the appeal had been heard. So what we added there was the appeal shall be heard no later than 10 school days after the request for appeal is received, and the appeals committee will notify the parent or guardian in writing of the decision within 10 days of the appeal being heard. You can see that appeal procedures in there. It goes first to the building principal or his or her designee. If not resolved at that level, it goes to the attendance office here. They develop a committee. They take the appeal after it's presented in writing, and what evidence you have to present. But then we didn't have anything that said, how do we let them know then what we have done? So that's what that section is added.
And these are appeals for an excused absence?
These are appeals for, well, you can appeal unexcused absences, unexcused tardings. If the building level didn't change and excuse them, then they can appeal to the central office.
Okay.
The next section on page 5, again, state mandated tests and gateway exams. We need to remove where it says gateway, and it would say end of course, and I didn't change it in the title, I apologize. So that should say end of course exam. And I've marked through wherever it said gateway to leave end of course. And then the last sentence said this shall take effect at the beginning of the 2008-2009 school year, which is not necessary any longer, as it is in effect now. The next 14 and 15 lines, all students who miss the scheduled gateway test must take the test at the next administration. There are no gateway exams any longer, so that should be deleted. And then the page that I've attached is the new section. This is by that new regulation the State Board of Education passed. The director of schools or designee shall also comply with state law regarding reporting of truant students to the proper authorities. In addition, the principal designee shall initiate meaningful communications with the student and parent or guardians in order to determine the underlying causes of the unexcused absences. The principal or designee shall then develop an attendance plan and coordinate additional services designed to improve the student's attendance. Upon notification that a student has been absent 10 days without adequate excuse, the principal or designee shall attempt to meet in person with the student and parent or guardian to determine the appropriate services needed to improve the student's attendance. The principal or designee shall document all communication attempts and refine the attendance plan as needed.
Can I ask a question on the military, please? Do we have anything for teachers that have their own children serving?
I don't think so.
I know I was in this situation because I had 3 in at the same time. And you only get 2 personal days.
Right.
So unless you lie and use sick days, then you're, and I just don't think that's fair if everyone else has the benefit of having this, then I think the teachers should have something there too.
It'd be something you could bring back in August when you do, we'll meet again in August, you may want to do that.
Put that in before the school year takes place.
We actually, I believe, plan to have our leave policies on the next agenda, to look at some changes, and so that would be something we can consider at that time.
Perfect.
Anybody else? So if we can go ahead and vote on this and get a motion.
So moved.
Second.
Good motion by Mr. Young, or,
Mr. Young.
all right, second by Mr. Eads. Any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion passes. Number 11.
Okay, number 11 is not statutorily required, but one of the things that TSBA recommends, just based on the way things change in technology, and they suggest that we include in our policy where we refer to communication devices, and we have a long list of things there, that we add to that wearable technology such as eyeglasses, rings, or watches that have the capability to record, live stream, or interact with wireless technology.
And are we saying they can have that?
We're saying the same thing as we had with other communication devices. They can have them as long as they are turned off, put away, don't make noise, unless your teacher has invited them into the classroom as part of bringing up technology.
Perfect.
TSBA told her that there's some school systems are having Google glasses already with some students.
So how do you
So this would
differentiate?
really,
How do you determine if they're turned off if I'm wearing my Google glasses?
how do you,
Technology
we
person.
we need to ask Mr. Nipperdale.
We don't use cameras in schools, my students, do we? I mean, that's sort of a forbidden
About
thing.
Not unless they are part of the
In a
project.
particular,
That's
right,
last.
particular thought, so
I'll have some.
wristwatches are going in.
Yeah, no. Got my wristwatch here.
All right, anybody got any further questions on this one? We'll get a motion.
So moved.
Get a motion by Mr. Eads.
Second.
Got a second by Mr. Holliday. Any further discussion on this? All in favor, say aye.
Aye.
Any opposed? Motion passes. Number 12.
Number 12 is Student Disciplinary Hearing Authority, 6.317, and the only change to this would be, TSBA recommended, just to clarify, the statute on this topic requires that the Disciplinary Hearing Authority provide written notification to the parent or guardian of the student and any other appropriate person of the time, place, and date of the hearing. And we have within 48 hours, which is not in the statute and not in the TSBA policy, so I suggested we remove that. The hearing has to be held within 10 days from the beginning of the suspension, so that's your adequate time frame there. But it does say written notification, which we didn't previously have in policy.
Move to approve.
We're gonna,
Yeah, we can take this one.
Oh,
we're
sorry.
gonna catch 12 through 15.
Okay, the next one is 6.4001, surveys of students. And you see on line 8, we will remove line 8, the first line there, and then add what I've asked right there, section number 1, which is on the second page. This is statutorily required. Prior to the dissemination of a survey, analysis, or evaluation to students, parents or guardians shall be notified of their ability to review the materials. Such notification shall include information indicating the purpose of the survey, analysis, or evaluation, as well as who will have access to the results. Following such notification and prior to the administration of the survey, analysis, or evaluation, parents or guardians may opt their child out of participation. The director of school shall develop procedures for granting such parental requests and to implement the provisions of this policy.
Any comments?
Not gonna stop all surveys, I guess. There's some of our local things like CADCOR and all that do surveys sometimes to apply for federal grants for, drug programs and assistance to students and all, but I wonder how they're gonna survive with these. It's statutory, there's nothing to do about it. It's gonna be tough on them to be able to probably get rounded data to be able to apply, so I don't know.
You know, you don't immediately make the connection to the Common Core provisions and the park testing and all of that kind of stuff, but there's certainly an element of that is related to this statutory change as well, because the park testing came along with the demographic survey information, and I think that's very likely a part of this legislative intent.
Well, let me ask you another one. For instance, on the Explorer test and ACT test, there's a series of survey questions that a student is asked about their aptitude and their interest, and this feeds back, after they take their test, feeds back to parents what your child might be best suited for or showing propensity to do. Can you make ACT show them that survey ahead of time and all? I say, this was passed by the legislature, but again, it may be so narrow, I don't know what'll happen here. There's some implications, what I'm saying.
Yes.
I understand the intent, but the other side of it, I don't know. I don't know where that stands, and that'd be a good TSBA
It's a very
question.
good question, like how far.
Explore, plan, ACT. Does your IB exams do anything, Bill, like any interest inventory?
Or less than the ones you mentioned.
Even the military one, the one that we give, ASFAB, would apparently fall under this also, because it wasn't ruled out by the legislature. I don't think we have a choice. I think it's statutory, but I'm just saying.
Let me ask, how far ahead do you give notification? Is it gonna be 3 days, 10 days?
Well, I mean, the statute doesn't specify a time frame, but it's clearly gonna have to be enough time for the parent to have time to come and look at it.
Right.
Or to, view the materials.
True.
So, and then we talked about as well that, the problem would be if you start having those requests, and then you have people opting out, if somebody has to be in charge of keeping track of who's opted out and who has not opted out. So if you're giving a survey to the entire 6th grade, all 6th grade students, somebody has to be in charge of making sure, those 8 kids or 9 kids that opted out don't get the survey.
True, but I'd like, I was wondering if we're gonna put a time frame on, say we give the parents 10 days to come and look at the survey.
Well, that will be probably one of the things that we have to develop in our administrative procedure,
Okay.
once we have some information about what direction the state's going in and those sorts of areas. There's about 3, as you see already, that we have to develop, procedures for, so that would be one of the things we'll consider.
Anybody else? Number 14.
6.600, student records. And you don't see any changes on this policy. What has changed by statute in this policy is that the new law says that if a student is transferring to a school either inside your district or outside your district, the sending school must transfer all academic records and all disciplinary records to the receiving school. But when we looked at these policies, we looked at our policy and we looked at TSBA's model policy, they were so different, and there was so much information contained in the TSBA model policy that was not in our policy. Mr. Odom and I both felt like that we would be better at this juncture to adopt TSBA's model policy, which has all of that language in there, and some that we don't have in ours, just because they were so different. At this point, there's a lot of information in the TSBA policy about access to student records, which is required under federal law, the Family Education Rights and Privacy Act. This information we put in our student handbooks as well, so just seemed appropriate to me that we use their model policy at this point because of the discrepancy between the two, and it contains the new statutory language.
Any questions, comments?
This wouldn't have any impact on a private school coming into public, would it?
No.
Or not? Because we used to have trouble if they hadn't paid a certain time, the private school wouldn't send us the student's record, and we were guessing sometimes
We
where
still
they,
have volunteers.
where they were.
It's gonna take a little while to read all that.
All right, I guess on that one right there, Mr. McCall, when you bring that to the board, you're gonna basically bring the TSBA policy.
You have it.
Yeah, I know what I see it back here, that's what
That
you're
would
gonna
be the
bring, okay.
recommendation at this point.
All right, number 15.
15 is 1.400 school board meetings, and this was not in the update that TSB sent out, but something that they added in the webinar that we had today. That line 3 in our policy and in their previous model policy had said every meeting of the board, except with the attorney to discuss pending litigation, will be open to the public and press. There is now a second exception regarding collaborative conferencing meetings that don't have to be open. So what TSBA has recommended that we do at this point, based on that added exception, is rather than list the exception, say that all meetings will be open, except when the law allows exceptions to that. So that was their recommended language, and that's something they added in the webinar today.
I think the discussion of school security, where statute allows us to have that as a closed meeting, would also fall into this area.
Any other comments? All right, we got items 12, 13, 14, and 15.
Move to approve.
Second.
Got a motion by Mr. Eakes and a second by Mr. Blair. Any further discussion on any of these? All in favor say aye.
Aye.
Any opposed?
I want to
Motion passes.
abstain, just because of 6.6, and we'll read that before we adopt it as board.
Yes, sir. Number 16, Ms. Cloud.
Let me make a request, Mr. Chairman,
Sir?
that Ms. McLeod actually read the bullying and intimidation part, just actually, for the audience and for the public, just to read that section.
Read what we got.
Yes, sir.
Okay, 6.304, student discrimination, bullying, and intimidation. And under the bullying intimidation section of the policy, it says, students shall be provided a safe learning environment. It shall be a violation of this policy for any student to bully, intimidate, or create a hostile educational environment for another student. Bullying and intimidation are defined as either physically harming a student, damaging his or her property, or knowingly placing the student in reasonable fear of such, or creating a hostile educational environment. The policy addresses conduct taking place on school grounds, at any school-sponsored activity, on school-provided transportation, or at any official school bus stop immediately before boarding and immediately following deboarding. Alleged victims of the above referenced offenses shall report these incidents immediately to a teacher, counsel, or building administrator. Any allegations shall be fully investigated by the complaint manager. You want me to go on with that? Then it goes on to say that during the investigation, how that will be handled, and that we'll try to maintain privacy if we can, that there's no retaliation against any person who reports or participates in the investigation. That essentially is that section, and then there is a section regarding how to file a complaint. So this policy is on the agenda at this meeting because the board requested we put it back on the agenda for this meeting to see if there had been any legislative changes that required us to add language to the policy. And according to our updates from TSBA, both in their information they sent out yesterday, along with the webinar that we had today, there were no changes that needed to be made to this policy at this time based on statute.
So the reason we put it back on here, you were anticipating changes, or you?
There were some proposed legislation that may have added some language to this policy, but it did not pass.
So you're saying to keep it the same, is that, because I remember last time, Mr. Reed, I think you said something about adding and other, any other? Or something like that?
We have talked about lots of, I guess, several different things. I think at the last meeting, we talked about leaving the same pending any kind of changes in the legislature that might be mandated from there. Right now, the policy is all encompassing in the sense that it does not tolerate bullying or intimidation for any purposes against any student for any reason. So it covers everyone for everything. So right now, it's a comprehensive policy that which does not tolerate bullying or intimidation for any purposes whatsoever.
Okay, I got an email the other day, I just thought it was odd that I was going to be talking about this, but it was from another staff person at school, and it had the U.S. Department of Agriculture has its discrimination policy at the end of the email, and it's a lot more definitive and more broad. So I have a copy, and I know some of the things don't apply here, but like.
Are you saying discrimination or bullying?
It's discrimination.
Okay, we're talking about bullying right now.
Yes, and this has some of the language that I think would be nice to add if we could put that in there. It has some of the, like we have the sexual, racial, ethnic, and religious discrimination. This adds race, color, national origin, age, disability, sex, gender identity, religion, reprisal, political beliefs, I don't think would be, I don't know, I don't teach high school. Familial or parental status, sexual orientation, individuals' income, I mean, it's quite lengthy.
Certainly, all those categories will be covered in the current policy. Once you start identifying specific segments of population groups, and if you exclude one, then the question arises, well, are you allowing bullying against that group or somehow not giving that other group the same benefit of policy that you're giving to the named groups that you name in the policy? By keeping it broad and comprehensive, you're covering all those groups evenly. And what you're doing is sending a clear message saying that bullying across the board will not be tolerated against any person for any reason whatsoever, which would include all those categories that you just named.
So why are they adding more definitive to that?
That's getting into discrimination claims, and those are some things that arise under federal law, federal regulation. So the USDA is a federal agency.
And you're talking about an employment scenario.
Right, they have quite a lot of more things added. I just kind of remember Sheriff Arnold last year at the commission meeting, when he talked about, bringing the SROs in. He said that, I guess one of the commissioners had complained about the cost. And he said for him, it was worth it if he could save one student's life from that. So I know we've had an episode of an attempted suicide. And is there a connection between the wording, would that make someone feel more comfortable, a student more comfortable if any of that was added?
My concern would be if you missed something.
Pardon?
My concern would be if you missed putting something down there.
Are you talking about adding to the discrimination part, adding all those names? All those categories? because there's two different sections here. There's one for discrimination and then one for bullying. Ms. McLeod read the bullying.
Yes, I guess to the discrimination, it would be just something where students would, if they're having a problem with that, I don't know, I don't really see that in elementary school where I'm at, I'm in first grade, but if a student saw that, say in middle school or high school and old, if it would give them some sort of comfort knowing that it is a legit bullying, something there.
Well, bullying of any nature is legit. So
Right.
if you're bullied, period, it's a legitimate complaint that should be brought to the school's attention, and the school should do something about it. So, whether, no matter what the basis for the bullying is said to be or alleged to be, if there's bullying going on, it should not be going on, and that student has a right to complain about it, and the school system has an obligation to do something about it.
And we do have we have a definitive policy in place that tells what happens if they are.
Well,
It is this policy.
that's handled on at school level, yes.
Well, and
There's-
according to the discipline code.
Yeah.
Now, it does tie, in the way I see this, discrimination / bullying. So it kind of ties them together. And in my mind, discrimination is a more subtle form of bullying in a sense. I've really labored with this, and I see that you've listed 4. Discrimination, line 6, sexual, racial, ethnic, and religious. I truly believe that if we enforce the policy, that these 4 will cover. Now, we're going to leave those in as they are, am I correct? Line 6 will remain as it is.
Correct.
Okay. In my mind, the concerns arise from gender preference or whatever our sexual orientation. But I think that we've said it right here, that we've covered the category that's been of most concern to folks. We just need to apply this in a rigid way, and we've got principals here that deal with issues of this nature all the time. But we don't need any type of discrimination or bullying. I remember the year 1962, when a young man entered Central High School. First young African-American, Mr. Wade, you probably remember that, wonderful young man. He had a tough time going through. Thank goodness there were no incidents detrimental to the student except the sort of subtle events that took place within the student body. So we need to be conscious of this, and if we continue with this and we see no problem, fine and dandy, we need to be open to the idea that that there may be a problem presented, and we need to be on top of that, and we need to not be unwilling to re-examine this sometime in the future. I like the policy as it is, as I say. I've done a lot of thinking about this personally. So I like what's written here. I think we can live with this for the moment, but I think we need to be aware that there should be no bullying of any nature. And believe me, I was a little kid. I skipped a grade in school. I was bullied a lot. It didn't impact me. Today, I don't think it impacts me to a great deal. But it's a real thing. It happens every day. You principals you're aware of that, and you fight against that. Every day you're looking for opportunities to say, whoa, wait just a minute. So we just need to be aware of this as a board. We don't need to be closed-minded. We need to be open-minded to the point that what we have, we would hope would work, and if we ever see a problem with it, we're open-minded enough to come back and revisit. So that's where we are, and I'll listen. I would make a motion if it's that time.
You know, I think we as a board and policymakers here have to ask ourselves that, do these 4 categories that are listed on line 6 and line 8, do they cover all what Ms. Mitchell has described in and the discrimination that she is listed. So I think that's what we have to decide right there. And
Okay.
I think we last time decided that this was it. These covered all of it. So I mean, you know, to bring it back up, okay, let's decide again.
I was just gonna say, I think Mr. Reed already made mention of that what Ms. Mitchell had listed was covered in all these.
Mr. Jernigan's.
Mr. Jernigan?
Well, I think one of the, we've talked about a lot of things here, teacher transfers, textbooks, a lot of things. But there's probably not anything more important for this group, in my mind, is to ensure the well-being and safety of our students and our teachers in the classroom. To create an environment that will lead to success of those people. Success of the teachers, success of the students. And I don't know the answer to this thing to ensure that. But there's three people sitting here that I know of that deal with this on a regular basis. I would dare say it's good, or at least on a periodic basis. And I would like to know if, without any pressure or any forewarning of this, just kind of know how they feel about it. I know when I was in the administration, that one of the most important thing I did, I thought, was to help our people be successful. And what does it take for students and teachers to be successful? Do we have it already, or do we need to add things? That's the question I have. And I believe there's some folks here that could shed some light on that and how they protect, because I know the three here, and I know that student success is extremely important to them.
I don't mind saying, those four categories are pretty wide and complicated. We do deal with specific issues, and there may be branches off of one of those four. Some come out, and the way I look at it, the way I deal with it is that any type of bullying or intimidation is addressed. And I don't have to necessarily go and see if it's in policy, because if a child is intimidated in any way in the school, then I've got to address that, regardless of what that issue is.
Most of, just curious, Mr. Barlow, most cases of bullying brought to you that you're aware of, or?
I'm sorry, did you repeat that?
I was asking Mr. Barlow, if most cases, I mean, you won't know about it unless it is brought to you, but,
It is, sometimes it is, sometimes it can come to you in a lot of different directions. It can come to you even as a proceed. A lot of times, if you just stand back and watch kids, they forget you're there. If you just stand back and watch, you'll have friends of kids, and you'll have parents of kids, parents of your kids' kids, who will bring, so it'll come to you from a lot of different directions, as far as how you get that information.
I guess while we're on this, since I asked you, I'll ask Mr. Ash, Mr. Spurlock, the same thing.
But we're fortunate that we have a STARS counselor. I don't know that we're the only one. I think we are full-time on the high school that United Way pays for. Her main job is to follow the procedure that the school board has in place when bullying is reported on a incident form. And she immediately handles that, and she distributes it to administration, to SROs, or to board counseling that she can personally do. So I think we have a pretty good handle on it, and these 4 categories, I can't think of an instance that I've had that would not fit in one of these 4. Some of them may blend 2 together, but there's not an area that I see that's not covered there, in what we deal with every day. And the policy that the school boards had in place on reporting those incident reports immediately has worked with us, but we do have a full-time counselor there just for that.
Mr. Spurlock?
Yeah, I would agree with Mr. Ash. We do have a STAR counselor also full-time. And those policy on bullying, I would agree with what's been said. There's nothing that, any behavior that would be considered bullying that would not fall within those categories. And I would agree with Mr. Reed that when you start adding to that, then you leave something out. And I think that's an opportunity to be prejudicial to a certain degree. Bullying is, I mean, we understand, we look at the definition of bullying, we understand what that is. And I think those categories cover everything that we've encountered.
All right, my last one would be, since Miss Mitchell's the educator, just get her feelings on it from your level, I guess.
I mean, there's a lot of people here, and I just feel personally that this is something that is going to be, I guess, the big, this is going to define, this is a history, it's coming to us, it's going to be coming, I think, to most school systems and most cities down the road, but it's something that if we don't do it tonight, make it, expand it, I think eventually there may be a mandate that we will. I appreciate you asking me. I just think if our standards, if we're always wanting to make our standards more, to lift the standards up, this, with the 4 things, it brings it down. And until everyone, I think, gets on board about what all we need to put in there, I'm just concerned about the students that might look at this and say, I don't really fit anywhere on that.
All right, and I agree with what you're saying. My only concern is if you miss one of them categories, when you start listing, that would be my concern. If you miss a particular one where you've listed all these others, where what Mr. Reed said, these 4 pretty well are so broad, they cover everything. If that makes any sense. I mean, I just hate to get into the start listing each individual thing and miss a certain one. That's, you know,
Well, I
There will
think,
be other things happening that will make this a little bit clearer, I think.
well, you know, I think we're all on the same page. And I've said this, and I always say it. I don't have any intention of our school system bullying anybody. I've told people that, and that's what I mean. I mean, if somebody's being bullied, they need to let somebody know. And I trust that our administrators, principals, and those involved will deal with it. But that's one thing I won't tolerate, bullying part of it. But unless somebody knows that somebody's being bullied, it's hard to do a whole lot about it.
Now, the counselor that they have at their school, is that just at certain schools?
No,
then?
I'm not aware that
The Star, is that what you said?
Yeah, I don't think everybody.
No, I don't
Ryan
think so.
Way's fund is large portion. I think maybe the only two that have, I don't know. Middle school might have, or high school, but I don't think they do.
They work some with the middle school also.
That might be something we could look at then.
Okay, I mean, I think we keep the thing open, keep the communication open and everything, and try to work through it all. But from a board level, and I've said it before, I gotta go back, I wanna make sure Mr. Reed has us covered. And I depend on him on a lot of it.
Well, to be clear, I think what the policy prohibits is bullying of any nature against anybody for anything. So it's all comprehensive. It's to include all bullying against anybody for anything. So that will be the gender issues, gender identity issues, sexual orientation issues, all of that. All that will be encompassed within the bullying statute we have. So that's what we're currently prohibiting. So all that is already prohibited by the current statute for policy that we have.
Can we go ahead and recognize that and make that amendment?
There's no amendment to it.
We
It's
keep-
in there.
It's already there.
This is already here, so I mean, this is,
That's what I understood it too, but glad you're saying we didn't have that.
Mr. Holiday?
It's a little bit of a different perspective or take on it, but I'm gonna share this because as we move forward, I think it's important for us to see these as two separate issues. Discrimination is discrimination and bullying is bullying. Discrimination includes sexual, racial, ethnic, and religious because these are federally identified classifications of people. And if the federal government chooses to recognize additional classes of people and do that by statute, then we would certainly consider that at that time. Bullying is a separate entity. We've discussed the idea that maybe anything that could fall into bullying is covered under these categories. I'll just throw out, you're a fatso, not covered under those four. You're four eyes, eyeglasses, not covered. Pizza face, pimples, not covered. Bedhead, shorty, your name is funny, not covered. You're crippled, not covered. So bullying is bullying, and bullying is something that, in particular, uniquely, kids have a great way of finding things that we can't possibly come up with all the different options as to what they can pick on one another about. And so I think we're heading in the right direction, that this policy is exactly what it should be. In discrimination, we acknowledge what the federal government has identified as protected classes of citizens, and we prohibit discrimination based on that. And when it comes to bullying, which can really get in the way of the educational process, it is simply not tolerated. Every student in every classroom is safe for every reason.
Could the first sentence in this, students shall be provided a safe learning environment, could that not be expanded just with a few words? That is, we use the term that it's inclusive of all students. Well, we've talked about it, but if you put that in there, in that first sentence, just those words, it's inclusive of all students. Would that be something that could be?
Well, Mr. Jernigan, the following sentence does just that. It says it shall be a violation of this policy for any student to bully, intimidate, or create a hostile education environment for another student.
Right, I realize it's there, but it makes it pretty clear without interpretation. And that's kind of what I was looking for. I'm not out to name groups or anything like that, but I am out for students to walk into that building and feel safe, and those teachers that are teaching to feel safe. And I can't separate teachers and students. I think I think we have some teachers that might be a little bit uneasy going to school this day and time.
I feel like, the names that was mentioned, Shorty, Four Eyes, and all this stuff, if it's offending a student, then they let the, person, the teacher, or whoever's in charge know that. And, I mean, to me, it's already included in all this. I mean, if you go to get real particular about all those things, and I think that's gonna cause further problems. If somebody is offended by somebody constantly calling four-eyed, and they feel that make them uncomfortable and everything, then they should report it to the person in charge, and they can be addressed. So, I think it's good as it is. There'll be some new things that come up and that you probably hadn't heard, you know. You never know what somebody offends somebody, but you try to identify them, you never identify everybody.
I'd like to, if I could, just go back to Mr. Jernigan's comments. Line 24 is what you're referring to.
Yes, very first.
What would, if you could repeat that again, I just want to see if it's, are you wanting teachers and students, or?
This is for section 6, so this policy is students. This is section 6, we'd have to put that in the teachers.
Did I understand you right, you want teachers to be included with this, is what I'm?
Not names of groups, just that all students, inclusive of all students.
So do you want to say students shall be provided a safe learning environment for all students?
Let me take a sentence structure.
Did you just say all
Students
students?
shall be provided a safe learning environment, okay.
All students shall be provided a safe learning environment. You can restructure the sentence and put the word all in.
Well,
If you want to do that.
I know when we have talked about the term inclusive, and that broad term brings in groups of students.
If it were this board's, the policy board, all of us collective, if it were the board's will to include that, students shall be provided a safe, inclusive learning environment.
What all does that cover, I guess?
That's it, your inclusive is emphasizing the word learning there, and you want to emphasize the student. I mean, it's just a modifier, I think, grammatical. I mean, I'm not good at that,
The
but
word students, plural, don't that blame everybody in?
it does.
I think we're largely all saying the same
Saying on
thing.
words.
So all this is semantics, I think, what we're talking about.
Students, that's plural, that's everybody.
Because I think it covers everyone now. It says students shall be provided a safe learning environment. We can add all students there, but still says that already.
With students.
Students, yes.
Well, you go with that, Mr. Jernigan. I'm just trying to make sure everybody's heard on all this.
It's a committee decision.
Inclusive, though, to me, if you had safe, inclusive, that's all encompassing, and it kind of hits everything without having to have each one of those categories, is the way I read it. I don't know if that's how you work. But it
I think there are lots of
includes-
things that could be interpreted to mean. You could be talking about an inclusive setting, you could be talking about inclusive with people. I don't think that's definitely, that's not,
I don't know what it would mean in that context.
yeah, I don't know
I
what
think
it
it'd be-
means. There's lots of things that could be interpreted to be inclusive in that.
It's just not clear. So if you want your policies to be clear and easily understood to the extent you can. So when you're adding additional language to it that's less clear, it creates arguments for people or both sides argue about things. And like here, we have a bullying policy that you're, in any bullying instance, you're gonna have someone alleged to be doing the bullying, and you're gonna have the victim of the bullying. So if you have to take disciplinary action against the person doing the bullying, and he ends up getting a lawyer or trying to appeal something that the school system does from a disciplinary standpoint, then you don't want to leave caveats in there that allows an attorney to argue on behalf of the person doing the bullying, gets that person out of it. So the simplest language you can use to be all-inclusive, to not include bullying of any type, is what we should use. Because any bullying instance, you will have two people on both sides of bullying, the perpetrator and the victim. And we may have to take disciplinary action against the perpetrator. You want to make sure you have full recourse to do that and not be hurt by your own policy in doing that.
Anybody else? So if you could, unless anybody's got any more comments on this, Ms. McLeod, just keep this on your forefront for the next meeting. Anything pops up or anything the committee needs to know about. If you want to, why don't you go get your stuff on textbooks, and I think 17, 18, I think you mentioned Mr. Odom wanted us to possibly look at those. Well, if Mr. Odom doesn't mind, I'll let him maybe go over those. Just
The 1-4, we talked about this some back during the winter when we were out of school some. And so what this would do in applying that, you remember that you came back and added this to the classified employees and was dealing with that? So I think what we're talking about here is if we would put this in policy up to 6, where we had them, if you remember, they didn't have 6. And Ms. Nichols is here, she knows exactly what we're talking about in dealing with that in HR. But that was, it was an exception this year, but that we want to put it in their policy. That if the school is closed up to 6 days, then it includes them up to 6 days. That's basically what we're saying.
That includes all personnel.
We had the certified covered, but do you also want to include the classified? And I think that's what we're talking about.
Are there ever occurrences in preparing for the reopening of school, clearing sidewalks or such as that, where potentially we have a double duty circumstance, or is that resolved? You know, we call off school, we say nobody needs to be here, oh, wait a second, but we need our custodial staff to come in here and help us clear off the snow or throw the de-icer material or something of that nature. Is there anything there we need to consider?
Well, basically, that's like here at the central office.
Okay.
We changed the start of the day, but, we haven't had a case yet where we cancel the central office. In that, so very often your people in maintenance or in those things are given some leeway when they start, but it's not cancel for them. These are people who support the direct instructional program, is what you're talking about here.
Okay.
Is my interpretation of this policy. That would be the educational assistant in the school. That would be the person who works in the cafeteria that's supporting that particular part of the program.
Okay.
I think you'd have to give principals some discretionary powers, custodial staff or something, they need to clean the things that they would have to do that. I mean, I don't, that may require some change in wording, but it's educational assistants and food service workers will be paid for that.
but basically what you're asking us is to
It depends
include.
upon student attendance for these people, that's what we're saying.
Okay.
They ran out of days to be able to make it up, if you remember, is what happened to them. We allowed them to come extra time, but it wasn't possible for them to even make it up, the old policy, but it's unusual, but it happened this year.
I think it's the right thing to do.
Is this just, this is just administrative?
This is
Procedures.
administrative policies, administrative procedures address a policy that tells the principal and the other staff, it's exactly what Ms. McLeod was talking about here, that we're gonna have to go back and write how you apply this. The legislature said you shall do, but we're gonna have to write a procedure of how you do that, once we find out what elements they want included in it. Deadlines, dates, actual forms that'll be used, that sort of thing. So what this administrative policy does, again, is clarifies that again, how you apply those days out for educational assistants and food service workers.
So this is what you're proposing that we go through?
It's really kind of what you did this year.
Yeah,
I mean,
know.
that's why we got it here. And when I was listening to you, I kind of thought y'all were saying at the time, we really need to do that.
Correct, but I don't think they have up to 6 right now, do they? I mean,
They
well, they
didn't.
got 2?
They didn't, and they had 2, and then they worked partial days.
Correct.
What is it? They could make up 2 days, wasn't that it?
I think so.
Yeah. So is this something that, as a committee here, we need to vote on this?
Well, what we need to know, I don't think you have to vote on it. I need your opinion, more than anything in this, because I can put out administrative procedure, but I don't want to go somewhere that contradicts your intent of policy. So we thought it would be a good idea just to put it out here and give you a chance to wade in on this. And I mean, if no one objects, we can make this change.
I think it's a good thing to do too. It's the fair and right thing to do.
And this pertains to snow days, inclement weather
That's
days
what
more
we're
than
talking
anything,
about.
is
That's
nothing
what
else.
we're talking about.
More or less, you classified people.
We came back to you and asked for that change. Jeff Sandvig and Ms. Barnes came back to ask for that this year. This would just tell them to go ahead and apply it. You won't have to go back to the board to do it next time for up to 6 days.
My only question is, why do we have the asterisk statement at the end of the policy if we've already covered it in these individual sections? I don't want the redundancy to result in double pay. And I know that would certainly not be the intent, but it could be a claim.
Okay, so we need to check the language you think there so that it wouldn't be,
I just think it needs to be deleted, because I don't know what the asterisk refers to that's not already covered. There's not an asterisk elsewhere in the policy that it's, referencing back to. And it just appears like, if a classified employee, were to work approved by the principal, then they may still claim, I'm still entitled to 6 inclement weather days, even though I worked all my days. Because it says so right here with this asterisk, says I get paid for 6 days because school was closed. I worked, but I also get paid for 6 days. I just don't think it's a necessary part.
You're not, on the front page, what you're saying, you're basically getting 6 days.
Yeah.
And on the back one here, you basically, you got personal days involved with that. I mean, there's no reason to have it in there.
Right.
okay?
So if the committee's good with that, we'll let Mr. Odom proceed with that. Ms. Mitchell, you got anything?
No, I think it's a needed thing.
All right, 2.1.
2.1, this has been in place for a number of years, and some of you have given me calls that at the close of each year, we run into the second semester, kids that have zero tolerance or have been sent to alternative schools, that sort of thing, are not allowed to walk at graduation. And the reason they're not allowed to walk is this administrative procedure that's been in place for years. But several of you asked me, why do we do that? And I asked the 2 gentlemen out there today, those 2 principals, to kind of weigh in on this, how they feel about it, because they speak kind of for other principals, and even that Mr. Barlow is certainly free to also. But I think it would help you as board members to maybe understand why that policy's in place. or if we want it different, we could, I mean, it could be removed, but I mean, this precedes me, it's been there for quite a while, but it became an issue this year several times.
I'd like to hear from our high school principals.
Let's go first.
With us, and realize it's only when there's zero tolerance. That student has sold drugs or had weapons at school. His senior year, when we're about to put him in adulthood, and he's made a decision to bring drugs to my school, sell drugs, have a weapon, so that it's very limited when it's a zero tolerance. Mr. Odom has the power at any time to overturn that if he sees a need to, so there isn't an escape hatch if something happens that is out of the ordinary. But if he's a senior, he's selling drugs in my school, and he's sent to Smyrna West, I don't want him to walk graduation. He's gonna get his diploma, but I want accountability for him. He's about to be an adult, he brought drugs into my school, and either took them or sold them, or brought a gun or a weapon, or I don't want him to walk on the graduation. Any deterrent that we can have in a dangerous area to our other kids, if we want school safety, the more severe the punishment, the better. And zero tolerance is severe. And when you're a senior, you're going to be an adult, if you're not already, and you should be held accountable for that. So I don't want him selling drugs on January 5th, one of my students being arrested, taken off in handcuffs, and then at graduation, him walking with everybody else. He's going to get his diploma. I just don't want him in public, walking out after he's been in public, he's 18 in the paper, selling drugs, bringing a knife to school, and now I'm shaking his hand, giving him his diploma. I just think it's a good policy that when there's zero tolerance, and I think we have gap catching, special circumstances, that Mr. Odom can adjust that when it's an unusual circumstance.
I agree too. We also have a due process to be followed. They can appeal this to the disciplinary hearing authority, and even if the disciplinary hearing authority opposes it, they can even take it to you guys, the board. So there's some procedural type things that would prevent misapplication of the zero tolerance law. And I would agree with Mr. Ash. As a senior, a zero tolerance requires, in the way it reads, is 180 days out of school, but we know that the director of school has within his autonomy to modify that, and we do strongly encourage that, and most of our parents, just about every one of our parents will do that. So I would agree with Mr. Ash. I don't think we're doing anything that is going to harm the child, other than as they leave us, we need to set that standard. There's going to be repercussions for making a mistake, but it's not going to be to the point where you can't come back from it.
The question typically occurs because of those last couple of sentences. If the student is a senior and returns to the regular school prior to the expiration of the calendar year, we're not talking about school year, calendar year, the student may participate in graduation ceremonies at the regular school if the expulsion occurred during the first semester of the school year, and the student is returned to the regular school on or before the 10th day of the second semester, typically in January, what we're talking about. If the expulsion occurs during the second semester, or the student has not returned to the regular school on or before the 10th day of the second semester, the student may not participate in graduation ceremonies at the regular school. So usually any discussion occurs on those two sentences, those dates and times. In other words, you can't be expelled the second semester is basically what it says. And participate in graduation. You have any strong feelings about that is the question, because, I mean, you're getting the calls, you get calls like I do, and that's the only thing I'm asking.
But that's not particularly zero tolerance.
That would not necessarily be a zero tolerance, although typically, yeah, it could be another expulsion of another type.
Would you feel differently about a non-zero tolerance if that student had worked their way back into your school?
If it's a remandment, they can come back, or I'll let them walk. I just don't want them walking in zero tolerance. That's very limited.
Is that system-wide though, or is it?
Every high school follows that, the remandment. If they come back, they won't.
Okay.
So probably we could clarify this by writing for zero tolerance or in zero tolerance cases or something like that? Would that
I
clarify
guess
that?
what we have followed in the past, maybe we can make it clear.
I had one this year that didn't come back to my school till we set the exams, we got to walk because they were remanded. Cleared her off.
So if you get a telephone call now as a board member, something you need to understand what the administrative procedure is saying. Mr. Holliday, are you?
Yeah, I understand, and I understand why this has been brought up. And I have questions about the specific circumstances, but they don't pertain to whether or not the policy is correct and effective. And so they're not for this meeting. The policy, I feel, is correct and effective.
Okay.
All right, if everybody's good with giving Mr. Odom the leeway to go ahead and make that change.
Thank you.
All right, Ms. McLeod, going back to number 4.
Okay, going back to number 4, this bill in public chapter is 23 pages long. But in going through it and looking, I also looked at the statutory references that are listed in TSBA's policy for the inspection portion. The only additional statutory requirement I can find relative to our policy in the new public chapter is the portion that we've included regarding posting a list of approved textbooks, instruction materials, and sending a copy to the Commissioner of Education. There's nothing in this new law regarding complaint for reconsideration. Now, the statutory reference for number 5 on the second, for inspection, on the second page of TSBA's policy, both that United States Code and Tennessee Code reference us posting our procedures for inspection of all materials. So there's nothing relative to individual schools in either of those references.
But the TSBA stuck in the complaint and
The
reconsideration?
TSBA policy has both of those sections.
Yeah, I don't know why they did that.
Mr. Reed,
We
you
do
got,
have, in another policy,
any feeling?
we have a procedure for parents to file complaints
Yes.
about objectionable materials.
Right. Usually it's a library book or something.
Usually.
Or it could be a secondary or supplemental reading. And we act on that, and that's the process.
Yeah, I think that the language that TSBA is proposing for the complaint and reconsideration does not work very well with respect to how we go about adopting textbooks, the procedure we use. And I don't really understand what you would do about it if a textbook's already been adopted and purchased.
Right.
So it could end up costing the school system a lot of money to have to address those kind of issues. So if there's a complaint about a textbook, it needs to be made on the front end before the textbook's adopted. So certainly, that will be published, people will have public record to see what's going to be proposed on the school board agenda, and there's objections that can be voiced at the outset before the board adopts those books. But once they're adopted, to have some kind of appealing mechanism at that point or change could be a very costly proposition for the school board.
There will be some changes in textbook adoption committees too, that's statutory. It's not in the policies we're considering today, but we haven't gotten those guidelines.
That's the other 20 pages.
Yeah, but that's gonna be,
What the committee's made of.
and they'll tell us how that's done. The state, it's changing at the state level, it changes at the local level, but those guidelines just have not come down yet, you know. It's typically your textbook adoption committees do not start functioning till November, December, and then they vote sometime and bring it to you in March. You know, it's supposed to be done by April 15th. So I think there'll be time, and that's what the state will do. Somebody will give us the guidelines, how to incorporate those in policies later on, or administrative procedures, one or the other.
Mr. Holliday?
Ms. McLeod, speaking strictly to the copy of Rutherford County Board of Education 4.401, if we include the revisions that you have pinned in lines, say, 8 through 13, and then we strike the word diplomas in line 10 of page 2, would we be in compliance with statutory?
Yes.
I make the motion that we do those two things to this policy.
Second.
We've got a motion by Mr. Holiday and a second by Mr. Blair to, make those changes. We're gonna eliminate everything else. Is that correct, Mr. Holiday?
Worthy discussion, appropriate for us to review it, but correct, not for adoption at this time.
All right.
Where you're gonna see this last part is actually gonna be in another policy that was passed where people can examine all instructional materials. So I think TSBA has gotten a little confused and mixed textbook
Yeah.
selection with another policy that's gonna be all instructional materials. So there's actually two things the legislature did out there. I think they've confused the two.
Can we recommend that we go back and talk to them about those concerns and see if we can get that cleared up a little bit?
TSBA, I'll be glad to.
All right, we've got a motion by Mr. Holiday and a second by Mr. Blair. Is there any more discussion? All in favor, say aye.
Aye.
Any opposed? Motion passes. Anything else to come before this committee? I appreciate everyone coming out. I know we went a little bit long tonight, but I think we had a good discussion and productive. So hopefully we'll have Ms. McLeod will have our last meeting in August, which should wind us up for this year. All right? Nothing else, we're adjourned.